A camper's here.
Camper just walked in.
A camper's here.
Thank you all for coming out today. Welcome to the Banking and Consumer Affairs Subcommittee. We have a full plate today, but so let's start off first with an appetizer. Madam Clerk, will you call the roll?
Representative Barrett. Bricken. Camper. Faison. Garrett. Lynn. Sparks. Vaughn. Chairman Powers.
Here.
Chairman Powers, you have a quorum.
Thank you. We've got a few announcements to make. We have several groups here to testify and on behalf of the bill. So I'm going to give a few instructions about the testimony first to make sure that everybody's okay with the time limit and the time frame. Okay, any testimony that requires request to members who bring guests who wish to speak, you have to give 24 hours notice, and you all did that. The limit is 2 people per group, and they are allowed 5 minutes each. After the 5 minutes that you all split up, divvy up whichever way you want to, then we'll have a Q&A after that. So that does not cut into your presentation time. Before testifying, please state your name and the organization or department that you're with before you begin your testimony. And do you have any other questions about that? You can ask me when you come up, but we're glad to have you here today, and always welcome your testimony. We just had a whole lot that had applied to do that, so we kind of had to group everybody up a little bit. And so a little bit of housekeeping too. We're rolling House Bill 2091 to the heel of the calendar. So that'll be the last bill in the committee today. And House Bill 1819 will be rolled 1 week. House 1502 also will be rolled 1 week. And are there any personal orders before we begin from the committee? Leader Camper. You only have 5 minutes, Leader Camper. While you're doing that, I have a personal order, and I'll just go ahead. Mine will be real quick. She's sitting on the front row. It's my beautiful wife of 37 years, Tracy Powers, is here with us today. And Leader Camper, back to you. Oh, do you have one? Okay. We're good. Okay. Anybody else before we take off? Representative Lynn.
Mr. Chairman, I thought she was a movie star here to testify. I had no idea. Welcome.
Oh, that's a compliment. Thank you. Anyone? We got Chairman Bond. I can't see you. Did you have something? Okay. Oh, okay. You're here. Okay. Somebody else. Okay. Okay. Well, we're good. Okay, let's go. Regular calendar, item 1. That brings us, it's House Bill 1891 by Leader Lambert, and we got a motion and a second. Okay, Representative McCallum is going to be presenting this bill, and I see you have an amendment to the bill.
Thank you, Chairman. Yes, I do have an amendment on that bill. It's drafting code 013633.
Got a motion and a second on the amendment, and Representative McCallum, you want to go ahead and present the bill as amended?
Yes, sir. Thank you, Mr. Chairman. Members, this is...
Oh, I'm sorry. We need to vote on the amendment real quick. All in favor of the amendment, say aye. All opposed? The amendment goes on the bill. Now, sorry.
Thank you, Mr. Chairman.
Representative McCallum.
Members, this bill simply addresses social media sites within the state and the access to their platforms by minors. It requires that any minors who are wanting to have a social media account, be it, the numerous different platforms that are out there, that they require parental consent. It requires that these companies make a genuine effort to verify the age and verify the consent of those parents before they're able to have that account. It does retroactively apply to minors that have an account currently. There's a 14-day cushion for them to be able to go back and have their parents sign off on it. And it enables the Attorney General's office to take up basically consumer complaints against these companies and investigate them if there are infractions on this. And with that, I stand ready for questions.
All right, thank you. And do we have any questions from the committee? Chairman Bond.
Thank you, Mr. Chairman, and thank you, Representative McCallum. For this legislation, don't fumble the governor's bill. But anyway, I have some questions with regards to it.
No pressure at all.
That is, how do we know? How's it verified? And if this is in the bill language, I apologize because I did not bring that printed out text with me today. But how do we know that the people who are verifying are the actual parents? How's the social, and trust me, social media is one of the banes of my existence. So I am not a fan at all.
You have kids too.
But at the same time, how does this work in practicality? How does someone know if they are indeed the rightful guardian, the rightful parent? How do we know that this child goes with this adult? How does that work within the confines of this legislation? Because it seems to me that there's a lot of, that'd be pretty difficult to execute. I think we can all agree that we see merit in this effort. I do anyway. And I want to support it, but at the same time, we need it to be, we pass a lot of things that don't really do anything. And so for this case, I'd like to know, how does somebody comply with this?
Representative McCallum.
Sure. Thank you, Chairman. And Chairman Vaughn, I don't believe the bill speaks to this with any specificity. I do know that it kind of leaves the ball in these platforms courts to determine how they're going to carry this out. The bill, it basically says that they have to make a genuine effort to confirm this. We do have folks from the governor's office here sign up to testify if we want to get some greater level of specificity on that, though, sir.
Oh, I would love to hear that.
Okay. Yes, we'll go out of order then, and we have somebody from the governor's office. We have Hannah Richardson from the governor's office, and we'll go out of order and ask her to come up and tell us a little bit more about this bill. And please state your name and who you're with.
Am I on? Okay. I'm Hannah Richardson. I'm on Governor's legislative team. So Chairman Vaughn, you're wondering about the specificity of how social media companies would verify this. Is that your question, or both that and how the parent is verified?
I'd like to know the full money, Ms. Richardson. Just tell me how this thing is going to work and it's going to be practical for somebody to use, because I'd like for us to know what we're getting into. And I'd also like to know that if the words on the paper don't match exactly the way we think it should work, that we have an opportunity to improve some of the language so that we can get it straight. Because like I said, I think this is a valuable tool, but I don't want my knife to be dull. I'd a lot rather it be where we can use it. So if you could give us some explanation on it, I'd appreciate it.
The idea behind the language that we have drafted in the bill, it says the social media company shall verify. That's all that it says. They shall verify the age of the minor, and then they shall get parental consent. The reason why we didn't want to lay out specifically in the bill how they do that is because each company might do that differently. Technology evolves all the time, so we didn't want to put something in the bill telling a company how to do this and then a better way come about, or a different way, or they have a way of doing it now that works. We just wanted to leave that up to the company, because we think that it's just too ever-changing to put in the statute. And if a minor is able to open an account and a company thinks that they have verified, and they said, well, we verified and sorry, didn't know they were a minor, we tried, they would still be in violation of the law, because a minor still was able to open an account. And so the idea is that even if that happens, they would have to go that extra step and actually verify. So it's kind of putting the onus on them to do that.
Thank you for that. That's sound in the world of construction. That sounds like you've provided a performance metric as opposed to a means and methods of how they do that. But I do think that it is important, because if we're going to, I think that we just need to, this needs a little bit more vetting, and I would hope that y'all's office would be open to perhaps some suggestions on it, how we can make this bill better as it moves forward. But I certainly support the concept. Thanks.
And we'd be happy to talk with you.
All right. Thank you. Representative Lynn.
Thank you very, very much. I am in agreement with my most able and intelligent full committee chairman. I am for the bill, absolutely, but I would like to see that we employ some sort of verification process. Is there no organization out there that has best practices when it comes to verification of minors? I would think that, you know, somewhere in the United States or Europe or something, there's some standard out there that we might look to learn how best to do this. What I'm afraid is that there's just going to be a little checkbox that says, yes, I'm a minor, yes, my mom and dad agree, or something like that. I'm really concerned about that. I really think that social media it's just been, you know, very polluting for a lot of young people, and it's really a shame. It's such a shame. And I really would like to see parents have more control over that. Even where I work personally, I had a parent come to me. She was convinced it was the school who had so influenced her child, and it wasn't. It was the social media. And she felt like that horse was out of the barn. There's nothing she could do. And I'd like to give hope to other people and really look for a standard. So I will vote for the bill, but I am hopeful that maybe our Attorney General could develop rules of some sort. I don't know if there's rulemaking in the bill, but also that we could find an organization that has a best practice with options for being able to identify individuals. So thank you, Mr. Chairman.
Thank you. And the next on the list is Representative Garrett.
Thank you, Mr. Chairman. Thank you for being here today. I've got just a couple of questions. I've got a 15-year-old and a 16-year-old girl, and it won't behooved them that my 15-year-old will open up a TikTok account and then needs to be verified. And my 16-year-old said, yep, I'm your mama. I'll do it. And they put in the information that's my mom and they verify, right? So they got my 15-year-old, who I do not want to have a TikTok account, has a TikTok account because my 16-year-old verified that she was her parent. And so, which I wouldn't put it past them to do that. And so that becomes a problem, right? Now, I agree 100% with the sponsor's explanation that it should be on the companies. These companies are sophisticated. They make a lot of money. They should be able to figure out how to verify parents when they do this. But in that event that they have a conniving daughter and they decide to create an account, the bill has no language in it for an opportunity to cure. So if I find out because somehow my youngest daughter sends me a TikTok video that I do not open, but yet it came from her under her name, then boom, I know that she's got an account. I'll ask her mother and I'll ask myself, I didn't do this. My wife didn't do this. We notify TikTok or whomever it is. Can there be an opportunity to cure where they're not violating the law if we find out later that they've got an account that was unauthorized because they thought in their defense that it was verified and it wasn't. So I don't believe that addresses. Can you speak to that to see if that's a possibility?
Yeah, so currently the way the language is drafted is that if that happens, if you have a conniving daughter or conniving children that do that, so in the bill, you as a parent, you could go to the Attorney General's office and say, hey, my daughter was able to open an account and I didn't give my permission. They would then resolve that with the social media company. And again, they would still be in violation of the law, even if they thought that they had verified and gotten consent, because at the end of the day, she's still a minor and that was not her parent that gave the consent. And so while, again, we don't specifically spell out in the language how to do that, if she's able to open an account and she's a minor, they've already violated the law because it's a minor with an account. Second of all, they didn't get parental consent. They got your daughter's consent. So it still would be a violation of the law and they still would have to be subject to some of these penalties in the bill through the AG's office.
Yeah, Representative Gary.
That concerns me because I don't know anyone in my district that would know, hey, I can call the AG's office and get this taken care of. And then the AG is very busy. I'm not doing anything against our Attorney General or his office or anything like that. But that seems a leap for me for something that I think can be easily handled through the company and say, look, this was something that send an email. There's got to be a way to have communication with these companies to say this account really wasn't approved by the parent. And so it seems to be more effective if the company has a time to cure that rather than boom, it's an automatic violation of the law and we're getting the AG's office involved when I believe it could possibly be taken care of well before the AG needs to be involved. So I would highly recommend something like that be included before I believe I can support the legislation. So I just want to make sure that's there. So I just appreciate the comments and thank you, Mr. Chairman.
Thank you, Vice Chairman Bricken.
Thank you, Mr. Chairman. Just a quick question. This bill, if it passed, says becomes law effective immediately. It seems like you would want to put a post date out there to give the social media companies time to set up the proper platform. Oh, well,
Okay, yeah.
I was sorry. I was either one. I'm sorry.
Did you want to comment?
That's certainly something we could entertain. We have it in here that when the bill is effective, they do have a certain time frame to resolve any minors that might have it, but we can certainly consider that.
It just certainly seems operationally, it seems like anytime you put something like this, we would need to put a post date out there to allow the companies time. So thank you.
Okay, thank you. Representative Barrett.
Thank you, Mr. Chairman. And speaking of conniving daughters, I have two of them as well. 23 and 20 now. And from a personal experience with my daughters, and not to disparage any one provider of social media, but my oldest daughter had a Facebook account, opened it up, and got tired of it because that generation's moved on to other things. And at the time she was 18 or 19, I forget. But she turned that account over to her little sister, who was a minor, who went in and changed the the photos and the account information and where the emails it goes to and the whole 9 yards. So how are we going to put the social media company on the hook for something like that they really don't have any way? It's an existing account. And I don't see anything in this bill that addresses that.
Yeah, I certainly see that concern. So I guess in that situation, if your older daughter has turned it over to your younger daughter, assuming she changes the name on it, like she didn't keep the name, again, the onus would be on the social media company somehow to do that. We, again, don't list it out. It would be on the company to figure out a remedy to that.
Representative Barrett.
So again, if you go to my middle daughter's Facebook account right now, you cannot tell that was previously held by someone else. Essentially, her older sister's been scrubbed, and it's her account for all intents and purposes. So, I just don't know how the intent of the bill is to try to put the onus on the social media companies to help us monitor these situations. And I just see a lot of end arounds that are going to put the companies in a bad position. And I agree with the chairman, Vaughn, that the intent's right, but there's probably some work to do to make it a little bit better.
Yes,
Thank-
sir.
All right. Thank you. And Representative Sparks.
Bob Dylan once said, times they are changing, and they certainly are changing. Chairman, I finished a digital media class last semester at MTSU. My professor, Dr. Raj, is kind of like a TikTok celebrity. And I was asking the students, how many watch the news? 0. That's where they get their news, Instagram, and all that. I've got the site pulled up about human sex trafficking. It was talking about that these are one of the recruiting sites. They're in 2020, they seen a 22% increase in online recruiting. And from 2019 to 2020, there was a 125% increase in recruitment on Facebook, 95% increase on Instagram since the previous year. I appreciate y'all's efforts. I think it's a good start in the right direction, and just want to encourage my committee members to support it. Thank you.
Thank you. Leader Camper.
Thank you, Mr. Chairman. The thing that concerns me about the bill is that we've seen here in Tennessee with the number of children who have been taken out of their home because of neglect and sometimes violence and harm to children. And some of these children have found support groups on social media to help them get through what they're going through. And if they're in a situation where the parent is the one that's causing the harm, it's going to be difficult for them to go to them to ask for permission to be on a social media site. So I don't think that that's necessarily addressed in here, but I think we need to think about it because some of them find a way to even tell somebody what they're going through from being in these groups on social media that's helping them, one, deal with the pain that they're going through, but also giving them the courage they need to tell somebody to get them out of the situation. And a lot of times it's been the parents. And we've taken children from their parents because of this. So and I know that may seem like a small group, but it's probably larger than we know. And I think this would impact their ability to do that. And I think the children are probably going to still go on these sites to get the comfort that they need and the courage that they need to get out of that situation. So I would encourage you all to think about that as well as we move through. I mean, we understand the intent, what you're trying to do. It is a lot going on social media. And I do feel like parents need to know, what their kids are. My 11-year-old grandson, when he's at my house, I'm like, give me that phone, what you doing? So I get it. But it's always this possibility of some unintended consequences. And I would not want this group of kids to feel like they don't have any options anymore. So just think about that, Mr. Sponsor. Let the governor know we're concerned about that.
Yes, ma'am.
Thank you, Mr. Chairman.
Thank you. And I think that's all the questions. I have a quick one, I think, but I didn't see the word conniving in the bill, but I did see parental guidance and parental discretion. And so I just wanted to ask you about, we have, unfortunately, today we have so many families that are split up, and then one family may even move to another state or, of course, another household. And how are you going to be doing defined about who is actually responsible for giving that consent to the child? How are we going to determine that?
Yeah, that's a valid concern. And that's another instance where we're just requiring the social media company to get parental consent. And so if they're in a situation where it's a divorced household, they could get consent from one parent, and that's enough under our bill because they've gotten consent from a parent. It just has to be a parent, and anything past that, if one parent does, one parent doesn't, then that would have to be addressed elsewhere.
All right, thank you. I think that's all, and I think we're ready to go back into session. And Representative Barrett, going back to you.
So, Mr. Sponsor, having heard some of the discussion here and some very good questions, would the sponsor be willing to roll this bill for 2 weeks to give us an opportunity to work on that?
Representative McCarroll.
Thank you, Mr. Chairman. Representative Barrett, you bet I would.
Mr. Chairman, I
Yes,
move.
you making a motion?
Yes, sir. I move we roll this bill 2 weeks.
Okay. We got a motion and a second. All in favor say aye. Aye. All opposed? The ayes have it. The bill is rolled for 2 weeks. Thank you, Representative McCallum.
Thank you, Chairman of Committee.
One little housekeeping thing too, I forgot to mention, we had Chairman Gonzalez from the, he's a commissioner of financial institutions. He was going to testify today, but we had a lot of things to go over and a lot of witnesses here today. So he has agreed to come back at a later time, probably next week. We're still working out his schedule, and in 2 weeks. He's going to be here in 2 weeks. I just got a signal from the back of the room. So he will be here in 2 weeks. So we're looking forward to hearing that testimony from him. Okay.
Excuse me, Mr. Chairman, if I could.
Yes, Chairman Vaughn.
With your leave, being the father of a daughter, they can't help it if they're conniving. They're just martyring everybody else. And so I think we just need to show some love to the daughters out there for figuring all this stuff out before everybody else does. I feel like we need to go on the defense for them there a little bit. But anyway, they are indeed bright.
I agree. Thank you for that. And we're going to go out of order a little bit. We have Leader Lambert here, and we had moved him down the calendar. Now we're going to move him back up. So the next bill on the calendar was item number 2, and it's House Bill 2091 by Leader Lambert. We need a motion and a second. We have it. Leader Lambert, you're recognized.
Thank you, Mr. Chairman. And this is a bill that really comes from, it's an administration bill, but this came from something that I've been working on for a long time. AI is going to change our life. It'll change our entire world, probably for the better, but without guardrails, certainly could be for the worse. You may have seen on social media 6-8 months ago, there was an AI bot that created a song. And that's what got me interested in this, because I saw that. I thought, wow, that sounds like a unique song. It sounded to me like something that somebody would have come up with. It's not what it was. What AI is what any other computer does. It is a combination of the information that is put into it. And so it takes millions of songs that it compiles from the internet and puts it into the ultimate mixtape, for lack of a better term. And it's a mathematical computation on what we as humans might want to hear. Now, that takes out, to me, all the magic, all of the inspiration, all of the uniqueness that is people. We were at church on Sunday, and like many of y'all, nobody fights like church fights, right? And so we have a discussion in our church. We call it a discussion in the Baptist faith on whether or not the old school music or the new school stuff is the best thing to hear in church. Now, by the way, I will tell you, I think that's a ridiculous thing to get into a discussion about, but other people think it is extremely important, and I respect that. I hate to break it to the folks that only like the old school music. Amazing Grace was a newfangled song at some point. And the reason I mentioned that is because when I said that word, I bet you heard a singer in your head singing that. There's songwriters and singers. I mean, folks like Willie Nelson, and yes, I went from Amazing Grace to Willie Nelson. Hang with me, okay? But there's folks like Willie Nelson or Tina Turner or the Beatles or Garth Brooks. When you hear the first few chords of a song, you immediately know what the rest of it's going to be because it's unique. It's something that a computer can't do. And so what this bill seeks to achieve is that we would protect people. We would protect artists. We would protect songwriters. We would protect their voice. The voice I'm using right now, an AI bot could take and could call you on your phone, and it would sound exactly like me. It would give the same reactions more than likely that I would give. And it is literally good enough that if they want to create a song from millions of singers and songwriters that are never getting compensated and never getting recognized, they can do so right now. I simply don't think that's right. That's what this bill does. And we're going to get into all the legalities of it and minutia and everything else. We've got lots of testimony, I'm sure. But Mr. Chairman, that's what the bill does. And for me, I want to make sure that we still have some inspiration in this world from our singers and songwriters so that we as people do not get lost in the process. I stand ready for questions. And in fact, before we do that, I know we have several people to testify.
We do. Yes, we do. And we have a lot of people that like your bill, and we have a few people that don't. So let's get everybody up here to, we're going to do them in this order. The first group we're going to have up, we're going to have Jamie Moore from the Nashville Songwriters Association International. And with him, we're going to have Chrissy Metz from the Human Artistry Campaign. And we'd like to have you both come up, and you can talk amongst yourself, but you got 5 minutes totals and between the both of you, and then we'll have a Q&A after that, okay? And first of all, Mr. Moore, I called your name first, so if you don't care to go first, and tell us who you are and who you're with, please.
There we go. Here we go. There we go. All right. Thank you for the opportunity to speak. Here we go. All right. Again, thank you for the opportunity to speak today. My name is Jamie Moore. I'm a member of the board of directors of the Nashville Songwriters Association International. I write songs for a living, songs that make you laugh, songs that make you cry, 3-minute stories that touch lives. Music is an important part of the fabric of the state of Tennessee. It's a part of our culture, economy. Music is our lifeblood. Tennessee has always held its creators at a high esteem and sought to protect their work and their livelihoods. We are at a critical point in American history and in human innovation. I'll say that again, human innovation. The development and light speed advancement of generative artificial intelligence has the capacity to end the business of music as we know it. As songwriters and artists, we spend countless hours on the quality of our art. We scrutinize every word that we write. Recording artists scrutinize every song that they choose to record, every product they lend their name or likeness to. That is their brand. For songwriters, the songs that we write, that is our brand. When a machine can take those songs born from a lifetime of my experiences and produce a record that an artist never authorized, never even sang, resulting in a fake version released without permission or payment, that is wrong, that is theft, and we need to protect against it. The Elvis Act modernizes current Tennessee law by adding the word voice, making it crystal clear that unauthorized AI-generated fake recordings are subject to legal action in the state of Tennessee. Given the state's track record, it's no surprise to me that Tennessee is at the forefront of protecting creators by telling the rest of the world that human creativity is important and must be guarded against those who seek to prey upon it. Governor Bill Lee, Senator Jack Johnson, and Representative William Lambert have my utmost gratitude for taking the lead in instituting guardrails around generative AI. Broadening current NIL law is an important first step in what will be an ongoing challenge to regulate music created by generative AI. Thank you again for this opportunity.
Thank you. Thank you very much. The Elvis Act. That's only I
Got jokes.
Okay.
He was waiting on that. You were waiting on that. So good.
Okay.
You had to. You had to. I'm so glad you did. Hi.
Okay, Chrissy, would you go ahead, please?
Hi. My name is Chrissy Metz. I am here to represent the Human Artistry Campaign. So thank you so much for having me here again. My name is Chrissy Metz. I'm a singer, an actor, and author. I'm also a member of SAG-AFTRA, the Recording Academy, Country Music Association, the Academy of Country Music, and of course, the Human Artistry Campaign. Collectively, these organizations represent thousands of individual artists, performers, and creators who call Tennessee home. Nothing is more fundamental to each of us than our own identities, and everyone should have the right to decide what words come out of their mouths and how their likeness is used. It's just really that plain and simple. I'm sure you've heard increasing reports about people's voices and likenesses used in deep fakes, some to embarrass or hurt the victim, some to misinform. I can attest to the pain and fear coursing through the creative community, knowing that years of committed hard work, countless heartbreak, sacrifice, unwavering resilience, and the dedication to our craft and our careers, not to mention our own character and our reputation, can all be torn down in a moment by an unscrupulous and unaccountable deepfake. Moreover, it's not just creators like me, it's all of us. Fake recordings and images have been depicted for political leaders using vile language against their colleagues or opponents. High school girls' faces placed upon other people's bodies in pornographic depictions, and older adults falling prey to financial scams. AI technology is getting better and faster, and while it can be used for great purposes, the abuse and the prevention is essential, and it has to be stopped. This is why I stand proudly with the Human Artistry Campaign, a broad coalition of creators and organizations promoting the ethical use of artificial intelligence and understanding that AI can facilitate but never replace a fundamental human element of our creative culture, the culture that we have actually created through blood, sweat, and tears. We wholeheartedly support the passage of the Elvis Act, which will enhance existing law to reasonably protect individuals' voices and likenesses in the new digital age. I understand that some people have suggested that this bill infringes upon free expression of those who want to use my image, my voice without my consent. I think it's pretty rich to tell creative artists that they threaten free expression by supporting legislation protecting individual expression from being manipulated. I fully support free speech, and it's appropriate that this bill preserves all First Amendment rights. However, using someone's voice not protected by the First Amendment should not be allowed. So you can make Tennessee the first in the nation to address this problem head on, and we cannot thank you enough for your leadership. The Elvis Act is for all of us, and we urge you to pass it into law as soon as possible.
That was right at 5 minutes. I mean, it was perfect.
I'm an actress.
Okay.
We did it.
I
We
saw
did
the
it.
clock
I was
run-
like, "Brrr,
saw the clock
I gotta
running
go."
out. Okay. I'm sure we have some questions for these two. Do we have any on the committee? Do we have any questions right now? Oh, yes. Chairman Faison.
Thank you, Mr. Chair. Young lady, we want to hear you singing.
First of all, you think I'm a young lady? I love that. Thank you. Checks in the mail, and I don't really mean that. I know this is important.
Okay. Vice Chairman Bricken.
Thank you, Mr. Chairman. You mentioned that this would be the first legislation like this in the country. I mean, I thought there were several states that have already passed similar legislation. And if so, I'm not sure if it's you or some other presenter can talk about other legislation that addresses this, the voice element for this committee. So. I'll wait.
Yeah. Okay. Should be coming up in a couple of minutes to testify on that. Representative Garrett.
Thank you, Mr. Chairman. Thank you all for being here for this important piece of legislation, what sounds like one of a kind, at least up until now. It's even hard to define. I've asked many folks in the movie industry, et cetera, how do we define what artificial intelligence is, right? And I think we're struggling with that. So my question's, you may or may not know this, but there's folks that obviously don't like it. And I wanted to get your position on the ones that are going to testify that have particular problems, and I believe in the movie industry that believe this should be free out there, whatever's created, and use it in a way when it's fake, right? And I don't know, and with that, I don't know if you've ever been subject to this. You've been on a very successful program. You've done very well in your career, and you've got a successful songwriting career. I didn't know if you had any personal experience, maybe not necessarily something with AI, but something that's out there in your medium that's out there that just wasn't true, and then how that affected you all in your personal life or even your career. If there's something out there that says this is what's going to happen if AI is left unguarded and creates something that humans create and people can't tell the difference, like the sponsor, like Leader Lambert said, we're taking the humanity out of it.
Mhm.
That to me is very disturbing for what not only do we interact with platforms, with mediums, with movies, but our kids too, not knowing what's real, right? Nothing wrong with having an imagination,
Sure.
but it's an imagination, right? Can you comment on any of that if you have something to comment
Yeah, I mean, I personally, of course, I'm an actress, part of SAG-AFTRA, and we had discussed multiple, I mean, 6 months we had a strike about how do we really involve AI into this new world of acting and how do we protect ourselves? Because if we can just create AI actors, then actors don't have jobs anymore. And if actors don't have jobs, then people who work on sets, which are the crafty people, the grips, the gaffers, everybody, we're talking thousands of people who don't have jobs anymore. And it's just unfortunate that they have been creating these jobs and have tenure and 35 years plus, and all of it will go away because someone's like, oh, let's create a face from a face that already exists onto a body. And I've had that happen to me where they're like, wow, she's lost weight. And I have not. And and that's okay. And then people sort of, you're sold these bill of goods and people are like, wait, I thought you were this, I thought you were that. And they see me in person. And even just something as sort of small as that, my face getting put onto someone else's body, it's like, wow, like I don't want that, my reputation or my character to be challenged, whether people find it to be positive or negative that I might have lost weight. And that is such a small example, but it happens in every sort of way because they can. They can absolutely do that. And it's easy and it's at our, our cost. So
Thank you very much. I really appreciate that.
Yeah.
Thank you.
Okay. Thank you. Representative Barrett.
Thank you, Mr. Chairman. Kind of building off what he was just asking, we've been dealing with the situation for a long time where songs are where a track gets used from an old song and then they create something new with it. And I understand the concern with AI of using existing images or faces and or even songs that's already been created. But is this bill addressing the situation where AI creates something completely new? Are we shutting AI down completely from the use of that, or shutting the industry down completely from the use of that? So for instance, you mentioned AI creates an actress and plugs them into a scene. Well, if that is a completely new or fresh creation, albeit by an algorithm that's using data that's been plugged into it, are we shutting the use of that down as well, or are we only protecting existing human artists and their product that they put out into the world?
Could you answer that or do we wait?
Do you want to address that when you come up there? Like, no, we got you coming up to. Okay, yeah. Just put that in a note and bring it up when you come up.
All right.
Okay.
Thank you.
You'll come to. Okay. And I think that's all. I have a question for Jamie real quick.
Okay.
I know you're a songwriter. Anything we've heard of?
Yeah. It depends on what you listen to.
I'm
But
kind
yeah,
of a wide variety.
I've written a lot of country music. I wrote May We All for Florida Georgia Line and Tim McGraw. Chasing You by Morgan Wallen. Yeah. And I wrote some contemporary Christian music by Toby Mac, City on Our Knees,
Yes.
May We All, not May We All, Made to Love, Get Back Up, Speak Life.
Okay.
Yeah, so.
Well, great. Yeah, thank you. I'm actually an amateur songwriter myself. My latest one was I'm on a dirt road to heaven and I'm in four-wheel drive. But nobody has published it yet. But We thank you all for being here. If we have any more questions, thank you all for your testimony.
Thank you.
For
Thank
coming
you.
out. Okay.
Thank you.
You write that song with
I know, right?
Yeah.
Leader Camper, I'm sorry.
Thank you, Mr. Chair. Mr. Chairman, while we're transitioning, can I do a personal order?
Oh, sure.
Yeah.
Yes.
Members, could you make welcome the president of the Memphis Restaurant Association who's here in the back?
Oh, yeah. Thank you for coming.
Thank you for coming.
Okay, the next group we have up, Ben Scheffner with the Motion Picture Association. And I know you're not going to pronounce your last name correctly, but I've got Kathy Benelis. Is that right? Close. Okay, with the Motion Picture Association. If you don't care to speak into the microphone and let us know. And let's see, Ben, I have you on the list first if you don't care. And got 5 minutes total for both of you, okay? And then we'll have a Q&A after that. And please let us know who you are and who you're with, please.
Chairman Powers, Chairman Vaughn, members of the subcommittee, thank you for the opportunity to testify before you today. My name is Ben Scheffner. I'm an attorney at the Motion Picture Association, and I'm here with my colleague Kathy Benuelos. The MPA represents the 6 major motion picture and television studios here in the U.S., including companies like Netflix, Sony Pictures, Paramount, and Universal. Our members love producing movies and television shows here in business-friendly Tennessee, and we're proud of the fact that our industry is directly responsible for having an impact on about 58,000 jobs in this state, including paying over $1.1 billion in wages. In fact, Tennessee was recently ranked number 5 in entertainment production in the whole country. I'm here today because our members have serious concerns about HB 2091, which would significantly expand the scope of the existing Tennessee right of publicity statute in a way that risks interfering with our members' ability to portray real people and events in movies like 42 about Jackie Robinson or the Johnny Cash biopic Walk the Line, thus chilling First Amendment protected speech. Let me start by saying that we at the MPA have a long history of working together with our friends in the music industry, and we agree with them that unauthorized replication of the voices of recording artists to create new performances is a real problem, and that changes to existing law to address that problem may be warranted. We stand ready to work with the sponsors, the legislature, the administration, and any other stakeholders to come up with a solution that fixes the problem and protects Tennessee jobs. But any such changes to existing law must be carefully crafted to avoid interfering with filmmakers' ability to portray real people and events. We believe HB 2091, as introduced, is drafted in an overbroad manner that would restrict the type of constitutionally protected speech in which our members engage every day. Tennessee's existing right of publicity law protects against unauthorized use of individuals' name, photograph, or likeness for commercial purposes, that is, in advertising or on merchandise. This limitation to commercial uses is crucial, as it prevents the law from being used to censor portrayals of real people in movies, TV shows, documentaries, news broadcasts, and other forms of media that, unlike advertising or merchandising, are fully protected by the First Amendment. Think biopics like last year's Oppenheimer, or Ray about Ray Charles, or The Social Network about Mark Zuckerberg, or recent docudramas about O.J. Simpson or Jeffrey Dahmer, people who never would give their permission to allow those movies or TV shows to be made if the law required such permission. Or think about a movie like Forrest Gump, where the fictional Forrest character interacts with real people in fictional settings, including President Kennedy, President Johnson, and President Nixon. HB 2091 would add protection to voice to existing Tennessee law, which we agree is part of the solution. But Section 6 of the bill goes way beyond that, adding an extremely broad new right against unauthorized uses of individuals' voice or likenesses, which is not explicitly limited to advertising or merchandising uses. And also, it's not just about AI. The words AI or artificial intelligence do not appear in this bill. Those issues, coupled with the lack of adequate exemptions for portrayals of real people, like the examples I just mentioned, would chill constitutionally protected speech. Again, I want to thank you for the opportunity to speak with you today and look forward to working with all of you to arrive at a solution that protects the legitimate interests of recording artists, actors, and others while maintaining our members' First Amendment rights.
I'm sorry, Kathy.
Hi, Kathy Banuelos with the Motion Picture Association. Thank you. I just wanted to add that we appreciate Leader Lambert's leadership on this issue and understand that it's an important one that needs to be addressed. So we're ready and able to be a resource and an asset to, achieve, what are our mutual objectives to protect the overall creative economy here in Tennessee.
Okay, thank you. We have questions from the committee for either one of the guests. Oh, yeah. Representative, okay. Are you? Okay. Representative Sparks, I think we had you down first. Go ahead, and then we'll get Leader
Just trying to be a
Camper.
gentleman, that's all. Let me ask you, cost of jobs, you mentioned jobs. Can you go into detail about that?
Sure. Well, as I mentioned, our members love doing business here in Tennessee. It's a very business-friendly state. I think there are approximately 58,000 jobs that are supported by industry here, pay over $1 billion in wages. And one of the reasons that we like to do business here is it's business-friendly. This bill would chill the ability to make certain movies and television shows based on real people. Every time a studio decides whether to go forward with a movie, they go through a process called clearance, and they look at all the elements in the movie and decide, what legal risks are we facing? And right now, under existing law, it's pretty clear that if you portray a real person, you in a fictional setting or a docudrama or a biography or even a nonfiction setting like a documentary, that you're protected because existing Tennessee law doesn't cover that situation. The concern is that if this bill were to be enacted in its current form, it would be far less clear that you would have the ability to go forward and do it and make that movie. And your only hope would be one day maybe to convince a court that what you're doing is protected by the First Amendment. So yes, it would absolutely chill the exercise of First Amendment protected speech, making movies and TV shows based on real people and events. And it's a classic chilling effect under First Amendment law. There's if this bill is enacted, there are gonna be shows, there's gonna be movies that aren't made, that could be made today. And that absolutely will have an effect on Tennessee jobs.
Okay, thank you, sir.
All right. Thank you. Leader Camper, you're good?
Thank you, Mr. Chairman. That answered my question. I was concerned about the impact this would have on documentaries on people, like if we wanted to do a documentary on someone and they've since passed and we want to talk about it, what impact would this bill have on it?
Okay.
Well, it absolutely could. So there is an existing exemption in Tennessee law for, let me just make sure I get the words right. For a news, public affairs, or sports broadcast. So certain documentaries could be already exempted under existing law, but not all. So there's a lot of ways to portray people, whether they're living or deceased. Some are a straight up news broadcast like a documentary, but there's also docudramas, there's fictional accounts. I mean, I mentioned things like, 42 about Jackie Robinson, not a documentary, but it informs people probably more than a documentary would because it's more entertaining. So this bill absolutely could have an impact on the ability to make works like that. And that's why our members are so concerned. Again, I do want to emphasize that the concerns that Mr. Moore and Ms. Metz expressed are legitimate. We do not think that you should be able to clone somebody's voice, put them in a new song. We do not think you should be able to clone an actor or an actress and put them in a new movie or TV show without their permission. A bill can be written that guards against that kind of thing, but also protects our members' ability to make those kinds of movies and TV shows that I mentioned.
Leader Camper.
Thank you, Mr. Chairman. Do you have some type of recommendation to the sponsor that you could offer?
We do, and we have language that we're perfectly happy to share. We've shared with some already that would write in specific exemptions to make sure that those kinds of concerns, those kinds of movies and TV shows that depict real people are not included within the scope of the bill.
Thank you, Mr. Chairman. Thank you for your answer.
Thank you, Chairman Vaughn.
Thank you, and thank you all for being here today. This is really fascinating stuff. I happen to be a firm believer in name, image, and likeness value that's in the marketplace, and I really salute you artists. It's one thing that I find myself, I wish I had a talent. I have so much other than talent that I could just offer the world if I had something that people wanted to see. The looking into this, though, I think that we're all in violent agreement that we want to keep our creative class from being damaged by technology. I think that's a universal truth that everybody can talk about here. And it seems to me like we're trying to get a little sideways in here on some lawyering as the words that we use. And I understand the issue that the MPA folks have expressed, and I appreciate your last comment over the fact that you too were on board with us with regards to the name, image, and likeness protections. But I'm not an attorney. I wasn't even pre-law, but I do read and write a lot of laws, and so my question is, within this, I understand again that we're arm wrestling over some terminology, but from what I understand, with the right to publicity, we've added term voice in there. But what was taken out of the existing statute that creates issues for you? I know you've got language you'd like to see inserted, but what was specifically removed? Because if something wasn't removed, then you don't have that there today. And so that's what I'm trying to figure out about how big of a divide this arm wrestling match is gonna cover. And so that's one of the things that I'd like, and from my perspective, what this does is I'm trying to figure out the scale of the expanse that we've got to cover in this issue, or are we just going to have to pick a winner and loser? And we're okay with picking winners and losers. We do it here all the time. But we like to try to bring people into accord as much as possible before making that call. So could you talk to me about what you lost from existing coverage by the introduction of this bill?
Sure. So I first want to make clear that if all this bill did was add the word voice, we'd be perfectly fine with that. We have no problem with that. Voice is protected in a lot of other states, right, of publicity statutes. Again, we would have no problem with it being added to Tennessee's statute. The issue we have is not so much what the bill takes away from existing law, but what it adds. And specifically, it adds two new causes of action, actually. It's under 4725-1105. It proposes A2, and it creates a very broad new right against publishing, performing, distributing, or otherwise making available to the public an individual's voice or likeness. And it, unlike the existing part of the statute, it is not limited to advertising or merchandising uses. That, coupled with the fact that the exemptions for First Amendment protected uses in existing law are too narrow for our comfort, creates some real problems. Again, we've offered language to add some exemptions that make clear that the kinds of docudramas and biographies and biopics that I mentioned would not be covered by the existing statute. Again, while also protecting against the kind of thing that Mr. Moore and Ms. Metz were concerned about.
All right. Thank you very much. Mr. Chairman, I listened to this, and it's important stuff, but I don't feel like the divide, I don't feel like we're at a huge cross section. If these folks had a problem with the principles that we're trying to get here, I would think that the ability to span it would be something that we need to take pause on. But I'm okay with where we are today, but understanding that we've got to get somewhere different by the time this bus gets to the station. And so what I would say that I'm okay today with this, just knowing that this is a starting point, but I'm not necessarily sure that this is where I think our end point ought to be in my perspective. And so I'm giving a tentative support to this so far. I'm lending my support to this for this point in time where we are, but I think there needs to be some more. What I'd like to do is I'd like to perhaps lawyer down a little bit, and let's find a place that we can get together, not lawyer up, let's lawyer down, and let's get some words in here that takes care of all of these creative folks that do such a great job of entertaining us and making sure that they're that they get their due coming. And that's where I shake out on this. Thank you.
And thank you. And there's a whole lot of lawyers in the room right now, so we will not tell any lawyer jokes. But speaking of lawyers, Representative Garrett, we're going to.
Thank you, Mr. Chairman. To our full committee chairman, I feel kind of attacked over there for being one of the lawyers in the room. Lawyer down is an interesting concept, but in the odd sense, I absolutely agree with that because we are talking. I feel like I'm reading a Supreme Court opinion on image likeness, et cetera, right, on publicity rights. But my question centers around this, and if we could speak, hopefully, like we're talking to non-lawyers in the sense of the way I understand and read the Elvis Act. It's from your position, we have issues of commercial purposes of how that's defined and how we define likeness. And in the Elvis Act, it doesn't touch that. It keeps it the same. And so when we use that, and if the First Amendment is implicated or not, none of that's changed in this whatsoever if the First Amendment is implicated. So what I'm hearing from you all are more problems with what our current situation is rather than what this bill does. Because if what you are telling me that we have issues with for the way our current laws are, and they've been on the books for, I don't know, 50 years or so, and there's been no challenges to this as it relates to someone using someone's image or likeness, can you drum down for us, like my 16-year-old is sitting beside me, on what are we talking about when it comes to what your issues are? Because I've met with you earlier, and I still don't have a good concept of how this particular legislation is either one, potentially unconstitutional, or we have First Amendment implications when it doesn't implicate the First Amendment at all. And so I've got a disconnect on. I believe y'all have more concerns of the way our current law is rather than what this is doing. So is there a way you can describe to me that what your position is on why this isn't something to protect for those that spoke before? And I would imagine there's going to be more people to talk on why they disagree with you that maybe clear up my contention here. Can you provide any insight into what the actual issue is instead of what it appears that we're arguing about current existing Tennessee law?
Sure. So respectfully, we don't have a problem with existing Tennessee law. Existing law is limited under 1105A is limited to advertising and merchandising uses. What this bill would do, however, is add 2 new causes of action that are not explicitly limited to advertising and merchandising uses. That's where we get concerned. Because when you make a movie, when you make a TV show, that is not advertising. That is not merchandising. That is fully First Amendment protected speech. So the concern is that new 1105A2 and potentially A3 says that, again, there's a new civil action for somebody who publishes, performs, distributes, or otherwise makes available to the public an individual's voice or likeness without any limitation to advertising or merchandising uses. So now, if we want to depict somebody's likeness in a movie or TV show, or their voice, in a docudrama, in a biopic, we're not going to have to think, are we at risk of being sued under this new 1105A2? And that calculation is going to chill speech. It's going to make the lawyers at the movie studios who decide what to give thumbs up or thumbs down, green light or red light on a movie, say, you know what? It's too risky to make this movie about O.J. Simpson or about Jeffrey Dahmer, where we have to go to get their permission before doing that. That's the risk that this new provision, not existing law, but the new provision creates.
Okay. Thank you for that clarification.
All right. Thank you. And I just want to remind the committee, we've got 3 more groups coming up to testify, so we kind of need to, and if you'll notice the clock, we've got, and Representative, Chairman Faison, you're recognized.
Thank you. Quick question. And keeping in theme with the attorney on this committee, wanting to break it down for his 16-year-old. I want to make sure I get it and the committee understands what you're saying. And I think I understand what you're saying. for purposes of his 16-year-old getting it, I want to invoke Swifties, Taylor Swift right now. In my opinion, Taylor Swift is one of the greatest revolutionary musicians of my personal lifetime. I think she's an incredible, gifted musician, songwriter, and took it to Music Row and did what she wanted, revolutionary, and got what she wanted. What I hear you two saying is that you want the ability to write a documentary about Taylor Swift, whether she wants you to do it or not. And you think if we pass this bill, then the people you two represent can't come in and make a documentary on Taylor Swift. And that's your contention with this current law. Is that my understanding of what you're trying to say?
It certainly would increase the legal risk. Now, ultimately, the courts are a backstop, and you could go to the court and say stopping that would violate our First Amendment rights. We think absolutely that our members have the right to make a documentary about Taylor Swift. They have the right to make a biopic about Taylor Swift. They can do it sometimes with her cooperation, but what if she didn't want to cooperate? They still have the First Amendment right to make that documentary about her. This would increase the legal risk. This would, on its face, seem to give a cause of action to her that we would have to go into and convince a judge that we actually have the First Amendment right to do that.
Chairman Faison.
Thank you. Keeping with the chair of the full committee. So what I hear you saying is that you want the right to use the NIL of Taylor Swift without her consent and personally benefit on her NIL without her consent. Is that what I understand you saying?
In certain circumstances, yes. Now, to be perfectly clear, we do not think we should make a digital replica of her and have her act in a new movie. No one thinks that we should be able to clone her voice and have it be in a new song. But making a documentary about her, yeah, that is First Amendment protected activity.
I would also
Okay, any more questions for the,
could I just make a clarifying point too?
sure.
Just with respect to the broad new cause of action, it wouldn't just be about making movies. It's someone took a picture of any person and uploaded it and disseminated it. They could potentially be liable if they did not have that person's consent.
Thank you, Chairman Faison.
That begs the question then. Is the intent to protect a revenue source? And I guess when we get to the sponsor, but you're wanting to make sure that you still have a revenue source with everybody around, regardless of, I'm just trying to break down what I hear y'all saying, and that's what I feel like you're saying. And so you're saying you can't use, you want to be able to use anybody's NIL for your personal gain or your business's gain, regardless of their thoughts. Is that what I'm getting?
That is much too broad of a statement. We do not, again, if we want to make a documentary about somebody, if we want to make a docudrama about somebody, yes, we have the First Amendment right to do that. We do not have the First Amendment right to take, say, a digital replica of an actress and put her in a new TV series without her permission. That's not what we're saying. But there's a distinction. And, again, it's really important that the statute itself make clear which of those are allowed and which aren't. It's not just a matter of, well, you can go into court and win. There's a famous case that just concluded a couple of years ago in New York. The plaintiff was a guy who murdered his father, tried to murder his mother, and is serving a life sentence in prison in New York. Lifetime made a docudrama about him. He ran into court under New York law and convinced a judge to enjoin broadcast of the show. Now, Lifetime eventually won, but it was after 8 years of very expensive litigation bouncing up and down in the courts of New York before a panel of judges finally said, yes, you have the First Amendment right to do that. So again, from our perspective, it's really clear. It's really important that the law be clear up front so you know which kinds of uses are allowed and which are not.
Okay, thank you. And we need to thank you all for coming out today. We really appreciate it.
Thank you for the
Appreciate your
opportunity to
testimony.
testify.
We do need to move on. We have some other groups coming up. The next group, Wendell Moore and Jessica Richard, they're both from the Recording Industry of America. Thank you all for coming out today. And if you don't care to give us your name and who you're with for the record, you're good? Okay. So, okay, we only have Jessica. Jessica, would you please?
My name is Jessica Richard, and I'm a Senior Vice President of Public Policy with the Recording Industry Association of America. I appreciate this opportunity to speak in support of this landmark legislation. While the recording industry has always adapted to and embraced new technology, including AI, we must make sure that artists' basic rights are respected when it comes to the use of their voices and likenesses. Bad actors are abusing AI technology, hijacking actual artists' voices and likenesses to generate digital clones, undermining their bodies of work, and alienating their fans. This threatens their basic rights, our culture, and the economy. It makes sense that Tennessee is the first state in the country working to protect artists from these abusive uses of AI. Built off the strong framework of the state's current right of publicity statute, which my friend Mr. Scheffner discussed, and I disagree with him on the nature of the existing law. There is no exemption for movies under the law today, and it is not limited solely to commercial advertising, as he said. So I believe that all of the movies that have been released over the last 20 years that would be subject to Tennessee law are subject to the existing statute and potential liability there. Moreover, the Elvis Act is carefully crafted to address deepfakes and AI abuses, extending protection to individuals' voices and ensuring all rights remain covered in the new age of artificial intelligence. Tennessee's common law provides a person with a property right in their own voice and likeness. Strong common law doctrines of secondary liability also will attach to these new statutory provisions, and with them, this legislation will serve as a model for other state legislatures and the U.S. Congress to follow. Importantly, this bill respects fair uses and free speech. It assures that all non-consensual uses of another person's voice and likeness that are protected under the First Amendment remain available. This bill does not change the protections afforded to speech that currently is protected under the First Amendment. Mr. Scheffner said over and over, they have a First Amendment right to make these biopics, to make these documentaries. They still have that right under the First Amendment, and this bill does not change that. The bill's opponents want to allow non-consensual uses of another person's voice and likeness in ways that are not protected by the First Amendment. They want to avoid someone having a right that they can enforce against them that might cause them to litigate in court. Their economic interests in non-protected speech should not prevail over a person's basic rights. Some parties have also expressed a desire to limit the bill's scope to protecting only the performances of living individuals. To do so would deny the dignity and legacy of both living and deceased artists, as well as their families and estates. And it would also take away rights that have existed in Tennessee for decades. And finally, while I focused on protections for artists, it's worth emphasizing that the Elvis Act applies to everyone. All Tennesseans deserve to have their voices and likenesses protected, and we are proud to support this legislation and encourage you to pass it into law. Thank you.
And thank you. And do we have questions for our guest today? Representative Garrett.
Thank you, Mr. Chairman. Thank you for being here. And you've heard the Motion Picture Association. I was wondering if you could respond to some of their issues with how it implicates the First Amendment. And then you said something to the effect that the exemptions are there, so there's not, or the exemptions don't apply to the movie industry where they could have some liability for some of the things they've done. I just wonder if you can kind of respond to the issues from your perspective on what these issues are with the legislation.
So as far as the First Amendment goes, this bill does not change the protections afforded by the First Amendment. It can't and it doesn't. So to the extent movies are being made or other works are being created that are protected by the First Amendment, that doesn't change. What this bill does is gives a strong property right that protects against uses that aren't protected by the First Amendment and that can be enforced in that area. Where exemptions are being discussed that would say all movies or expressive works or documentaries or biopics are excluded from this, that would encompass material that is not protected by the First Amendment. And it would favor those interests over those of Tennesseans in their own voices and in their own likenesses. So what this bill does is it continues to draw the line at the First Amendment. Everything protected by the First Amendment remains protected. Mr. Scheffner several times referred to strong protections in movies. That stays. But that's where the line is drawn. And if something isn't protected by the First Amendment, this bill enables individuals to enforce their property rights in their voices and likeness and go to court and bring their case and have their day.
Representative Barrett.
Thank you, Mr. Chairman. Again, I'm just trying to think through this, so bear with me here.
Please.
Hall & Oates is in the news recently
Mhm.
with their issues. And so, as I understand the implications of this law, if they were to separate and Darrell Hall wanted to keep on performing,
Mhm.
he would not be able to use digital imagery or voice of John Oates on tour or create a new album or something along those lines using his voice without his permission, correct? Is that what we're trying to stop?
Generally, yes, you would need permission to use his voice in some new way or without his authority. Yeah, that would violate.
But this law would not prevent a biopic or a documentary talking about or covering their either the history of their music or this particular fight or dispute that they're having.
Right. So the First Amendment issues are generally dealt with case by case. So it would be a factual analysis for an individual case, but those types of uses generally are afforded strong protections.
So as the bill is written, the intent is to prevent the exploitation of someone's name, image, and likeness for pecuniary gain without their approval or permission.
And their voice. Yes.
And their voice. And it's that simple, correct?
At bottom, that's the aim. Yes.
Thank you. I'm trying to lawyer down here a little bit so that we can all understand exactly what we're trying to accomplish with this bill. So thank you for your testimony.
Thank you. And Chairman Vaughn.
Thank you, Mr. Chairman. I'm not sure whether or not we have more guests here today to testify. Okay, well, I'll say this and then I'll hush, is that I don't want to see perfect become the enemy of good and improvement. And that's one thing that I think that if we can mull this, we can lawyer down, we can try to get to reach an accord. But at the same time, if we're starting to define what is, then we've got some issues. And so what I just like to encourage the committee to let's deal with this today. Let's try to work with it moving forward. And I can assure you that we're going to try to get as much done on it as we can. But at some point in time, we may have to call a stop to it and say that we'll get it. This is as good as we can get. But where we wind up will be better than where we are today. And I think today there's a gaping hole that we need to fill. And so I'm all for that. And I'm willing to work with our friends from the motion picture industry to try to find something there that we can all say grace over. But I think this is something that I strongly encourage our committee members. Let's get this thing moving today and let's get it on, and then we can see if there's common ground we can reach.
All right. Thank you. Okay. And thank you so much for your testimony. We appreciate it. Thank you for coming out today. The next group that we have up is Chris Baker with the Tennessee Association of Broadcasters and Tyler Deers. Is that correct? Dyers, technical, and Google with Google. So if you all would come up and can you all split it up? We've got 5 minutes.
Mr. Chairman, I'm Mr. Baker's lawyer. We had asked to testify, but based on some other things that's gone on, we're going to decline to do that today.
Okay.
We're still interested.
Okay.
Great testimony.
All right. Thank you so much. All right. Thank you. And please state your name and who you're with, please.
Yeah, thank you, Mr. Chairman. Good afternoon, members of the committee. My name is Tyler Deers, and I'm actually with TechNet. We're a technology trade association. We represent about 90 innovative technology member companies. I am testifying before you today in opposition to House Bill 2091. I want to just start off by saying and stress that TechNet and our member companies understand the importance of this issue to the state and to your constituency, and the importance of protecting this vital industry. While our organization has a few concerns with the bill, we are not unalterably opposed to this measure. However, we believe there needs to be some additional amendments that maintain the spirit of the legislation while not thwarting any innovation and inviting any litigation. Protecting an individual's likeness is a worthy goal and one that has been done previously in law. Unfortunately, while the goal is laudable, this bill is drafted in such a way that the unintended consequences prevent us from supporting this measure as it is. From a technology perspective, we have some concerns with the bill in that it assigns new liability for making any technology available that can recreate a person's photo or voice without authorization. This bill goes beyond contemplation of a digital replica or even synthetic material and assumes that any use of another person's photograph, voice, or likeness in any medium is liable to a civil action. The way that the bill is currently drafted, it could potentially mean that any technology provider that developed or made available, for example, a generative AI tool that someone then used to produce a voice or likeness would then be liable, even if that was not contemplated by the developers who created the technology. And if you read it broadly, it could also include any photo editing software where someone could simply copy and paste someone's image into it. We have concerns that it could also impact app stores, for example, if you offer apps and make it available on the marketplace with these tools. Furthermore, the language, including in the bill, otherwise makes available, we view could also loop in cloud providers and others such as broadband providers, internet service providers that may be transmitting this material through their networks. We believe the liability should be on the person that is using the tool incorrectly, the person who is improperly using this and without consent, and not the entity that is simply making the tools that could have appropriate uses available. In closing, again, we are concerned that the bill is too broadly written and would have unintended consequences as it would target developers of innovative technologies. And again, while we are opposed, we stand prepared to offer the sponsor, the advocates, or the administration any language that could remediate our concerns. So with that, Mr. Chairman, thank you for allowing me to testify this afternoon.
All right. Thank you so much for coming. And do we have any questions for our guest? Anyone? Okay. If not, thank you so much for your testimony and thank you for coming out today.
Thank you.
Okay. And we're going to go back into session.
Mr. Chairman, lawyers can ruin the fun on just about everything, can't we? So, look, we could get at the minutiae of the language. I think everybody's still working together on the commas and semicolons and ands and ors. But at the core of it, it is what it is. The committee, I mean, you all have defined it much better than I ever could. So I'll stand ready for questions. But I just think someone's voice, especially here in Music City, in Tennessee, where so many forms of music have been born, it's just an important part of who we are. Many of y'all, the moment I hear your voice on the phone, it makes me smile because you're my friends and I recognize you. Children recognize their parents' voice. It's just a unique part of who we are. And like likeness, which is already in the statutes, I just think voice should be protected. So as the good chairman said, I think we can, hopefully agree that not to make perfect the enemy of good.
Thank you. And do we have any questions for the sponsor at Leader Camper?
Yeah, we look so much alike. Thank you, Mr. Chairman. Thank you, Leader, for your bill. I understand what you're trying to accomplish with it. I think we all get, what your intent is, but from listening to all the testimony and some of the concerns that people have with the legislation, I presume that you'd be willing to, should this bill move on, work with us, others, to make sure we got the language right, that there's no, unintended consequences that we could have addressed, as the bill moved. Will you be open to this dialogue as, should the bill move on?
Leader Lambert.
Thank you, Mr. Chairman. Madam Leader, always. But I will say, I think the bill's in a good spot the way it is. I disagree with some of what was said today in the testimony, but at the same time, always willing to work with anybody, especially when we're talking about some of the minutiae in it. I mean, I think everyone across the spectrum agrees that we should be protecting voice. It's just a bit of a disagreement sometimes on the wording of how we do that.
Leader Camper.
Last one, Mr. Chairman. Thank you for that. I really appreciate it. The last gentleman that spoke reminded me of something during my time in the military. And I served in military intelligence, and we had people who developed something for a purpose, a reason. that got in the hands of someone else that was thinking very nefariously. And so what could potentially happen to him is that they created it for one application, but someone else did something different with it, but they will be held liable. And that's another concern that I would have, that you've already said you'd be willing to work on. That's subparagraph 6A3, I think. So we could talk about it later, but I just hope that that's something we could think about, because there have been times when, from a national security perspective, that things like this could get in the hands of the wrong people, and then the wrong person or company, organization is held liable for it. And I would not want, I know that's not your intent at all, but when it talks about algorithms and someone else is using it for something else, that kind of sent a red flag for me. Thank you, Mr. Chairman. Thank you, Mr. Sponsor.
Leader Lambert.
Thank you, Madam Leader. And what I'm probably going to also do is, at some point, I know some of y'all may already have a red line version of this. I had my staff make up a red line version. It helps me a lot to look at what's in the statute already, which has been testified. Some of the testimony today is already in current statute, and then some of which is being added. So I'm probably going to go ahead, with permission, I'll probably have my staff go and get that to everybody, because it just kind of helps sometimes, because a lot of that's already in the current statute.
Okay, any more, I'm sorry, Representative Sparks.
Leader Lambert, as you know, a lot of legislation we pass have unintended consequences. Do you see us being back here next year on this same issue?
Leader Lambert.
Not on this bill. On AI in general, absolutely. I mean, there are so many different ways that it's being utilized. And just like the leader said, it could be a great tool. And with permission of an artist, this could be a tool that hones their product. It could be a tool that helps with some of the editing and everything else. With permission, it can be a good tool. Without permission, it can be a bludgeon that is used against an artist to really twist their work. And so I think this bill, if passed, we're not going to be back here on this issue, but we're probably going to be back here on a bunch of others involving AI.
Let me ask, Chairman, is there some type of working technology committee that's ever evolving, looking at this, that you know of?
Leader Lambert.
Not yet, but I bet we might have one soon, because it's one of those things that's going to be needed. I mean, this is going to get into just about every aspect of society. We're dealing with voice here. We're dealing with one aspect of this in NIL, but my goodness, there's a ton of other things that we could go into.
Thank you, Chairman.
Okay, any other questions for the sponsor? Got a question on the bill. We're going to be voting on House Bill 2091, and all in favor say aye. All opposed? The ayes have it. House Bill 2091 goes to full commerce. Thank you, Leader Lambert. Thank you
Mr.
all
Chairman.
for coming out today, for everybody coming to testify.
Thank you, Mr. Chairman, members of the committee, and we all thank you. Thank you.
Okay, I need to make an announcement too, real quick. All the other bills that were up today that we didn't get to, do I need to go over them individually? Okay, so they're all going to be rolled to next week's calendar. 965? Yeah, House Bill 965 is going to be on our special calendar. All the other bills will be rolled till the following week. Thank you all for coming out. We are adjourned.